All right. Glad you guys have come in on another Saturday. Appreciate you all. Let's get started with the questions. I'm going to have my co-host Isaiah here today to kind of assist me with answering you guys' questions. You guys should have seen the announcement that this will be our last, consecutive, Saturday upon Saturday Q&A call. We're going to have this once a month, but I want to be able to give you guys enough time in those calls. So when we do have it, which will be the first Saturday of each month, it's going to be about anywhere from 2 to 3 hours, as long as we need to take to get your guys' questions answered. So that's going to be once a month. And then I guess we're going to call that our super call, right? Those of you that are private clients by way of agreements with us, we will have your call every 15th of the month. Every 15th of the month, I will let you guys know what times, but that is going to be the power call for you guys, in addition to your monthly free consultation that you guys get with your assigned representatives. So with that being said, let me see if I can find Isaiah. I know he's in here somewhere. Let's see. Shoot. We're going to get started with your questions. But I believe Isaiah, he does have a list of questions that we have received inside of Patreon. So let's start there. Let's try to answer some of those questions before we get started with people who are raising their hands here. Hey, Isaiah, are you there?
Yeah, how's it going?
Pretty good. Thanks for joining me today to assist me. Getting a lot of people coming in, which is really good, this year, starting the new year off. So you guys are understanding the importance of this process and what to do. And I assure you this time around, you're going to start to see how to utilize your trust packet when it comes to the taxes. So that's going to be something I'm very, very excited to share with you all. What kind of questions do we have, Isaiah? As I, let people come in, go ahead and just read them off and we'll try to answer them.
Yeah, so the first question is from Craig, and Craig is asking, when the injunctions are filed, do they only cover the county where they are filed, or do they cover the entire state?
Good question. When your injunction is filed, you have 4 parties that you're submitting this out to. Now, it's not limited to these 4 parties, but we recommend your county sheriff, at least another county that's neighboring your frequent county, because you're traveling and not just one. I'm sure you're crossing borders of at least 2 to 3 counties. So do 2 to 3 sheriffs, and you're going to do the state governor. You're going to do the attorney general in your state, as well as your state's chief justice, the supreme chief justice judge in your state. So that will cover your immediate travels. Now, inside of the injunction, you are to demand, as a constitutional right, that the sheriff places you on the do not stop, do not detain list in his system, not only in his state, but in every other state. That's what he's supposed to do. We've seen that happen for people just by them traveling and being pulled over for things, and they noticed that the injunction worked in another country. So make sure you have that language inside your injunction, but it will definitely work where you are currently calling yourself home. All right.
Yeah, and then just to add to that, if you guys are doing your injunction yourselves, you would also notice that Avery's template says that it covers not only the state that you're in, but all other states. Now, we don't have a way to fully test that, unless you're willing to just go get pulled over, and I don't recommend that. But it does say that we're covered for the state that we're doing in and all other states.
All right, good deal. What do we got next?
We got a question from Melody. She says, hello. For DBAs, are we getting one for our strawman name, our business name, our estate, our foreign trust name, and our trust enterprise, correct? I'm in Michigan. I'm trying to be clear if those are the ones I need. Thanks.
Mm-hmm. Good question. Yes, you're going to need a DBA for all of those different formats of your name and your businesses. Going into the Telegram, well, if you're not in there, I need you to email our assistant, consultantrep@workmail.com. Give her your Telegram username and make sure your privacy settings are off. So that way she can properly add you. And just be sure to mention which membership tier you're in here in Patreon. So that way she can identify you and place you in there. So once you're in there, I want you to go through the archives in there. We left an example of one of our private clients who's gotten his DBAs done in just one affidavit to cover them all. And it was recorded in his county. It was filed in the local newspaper. So now those two actions make it an actual court record. Instead of you doing several different DBAs, which can be costly, it's probably best to go ahead and just list your express trust doing business as all of those names, all in one affidavit. So that's what we're doing. And you're going to see me break that down inside of the junior class in version 2.0. I've just recently uploaded version 2.0 for the freshmen. Those of you that are enrolled in the freshman tiers and those of you that are enrolled in the complete zero tax liability tier and even our private client workshop, you'll see that there. And, version 2.0 is coming for sophomore as I go along. And once I get to junior, you'll see exactly the major changes that have taken place based on the changes that these local municipalities are forcing our hand to do. My process when I did it a few years ago, and those that were doing it with me, it was very easy. And now that this information is getting out and more of you guys are doing this, they're going to try to throw roadblocks, no problem. But there is a way around it. So that's what 2.0 is going to be about, showing you how to get around those roadblocks and get you to the end goal much faster. Right?
All right. So there's a question from Thomas Teach. He's saying, I'm having an issue with my CRBA. Do I get that authenticated, apostilled, or certified?
CRBA, for those that don't know, it's a birth certificate that's given to those that are born abroad, but they're still obtaining U.S. citizenship. So most likely that happens when the parents are out of, in the military, and then you're born that way. It's very, very similar to someone that receives their certificate of naturalization from another country, and then they come into this United States of America. Now, in my personal opinion, both of those documents have the Secretary of State of the U.S. Department of State. His seal is on there, his signature is on there, and the date that he's providing that information. That is a complete authentication. So you do not have to authenticate it. I believe it already is. But some of you have done that, have taken it a step further to do authentication. Now, if you do that, that means you go directly to the Department of State. You do not go to your Secretary of State. Your Secretary of State has nothing to do with that document. So if you want to do it, by all means, you can. You're not going to find a section inside of Form DS 4194 to delineate what to select when you're doing that. And that's why I say it doesn't need to be authenticated with them. But I guess if you do it, you're probably going to select birth certificate anyway. So you guys can try to do it that way, but I really don't think that's a necessary step. Just take the document and place it inside of your trustee minutes as collateral inside of the promissory note as well. Okay. Good to go. Also, we got a note here from our Nancy, our assistant. She says, those who would like to be added to Telegram, please email me at consultantrep@workmail.com. She needs your full name, the class you are enrolled in. She needs you to update your username to have the letters T as in Tom, Z as in zebra, P for Paul, add it to your username, and the phone number connected to Telegram. And also you guys have to have your privacy settings removed. Otherwise she cannot find you and put you in the system. So that's a temporary thing. Just take it off. And then once you know that you're added into the 0% Telegram group, you can put your privacy settings back on. But if you have that on, we're not going to be able to find you or be able to put you in there. All right. Next question.
All right. So yeah, this next question is from Ronnie. I think it's a good question to answer in front of everybody, Avery. It says, hi, Avery and the TZP family. I was wondering if you need any additional help or if you were hiring help. I appreciate you so much. Thank you for your time.
Good question. Good question. You all know that, we do like to have our very own students who have successfully done this process through and through and have used it in a way that's very unique to them, because most likely other people have the same issues that you're going through. So without that experience, we would not take you in for that. But there is opportunities, and we have done that with some of you already who are currently with us. Some of them were our own private clients, and they have a unique skill and trade set that we needed to bring on. So that opportunity is open. And, all you have to do is just check back in with us and we'll see where your unique skill set can be applied as to the certain remedies that you've gotten, any kind of testimonies you have. Then yes, that is a possibility. But as of right now, we are really, really trying to get a hold of a lot of the different things that we're working on right now. So let us work on those things. We will get back to you in the future on that. So, but very good question. And I appreciate your zeal and willingness to want to help. What do we have? Is that all of them?
All right. So I got one more question from Brother Terrence. It says, good day. Typically anything that needs to be edited or updated in the forms is shown in red. However, there were no red highlights in the powers and duties of the trustee document. I know I would need to update the trust name and the names of the signers in the document, but what other information do we need to update, or do we leave everything else as is? Please advise. Thanks.
Well, that is a question that only you can answer. I have provided a document to give you an idea as to what goes inside of your trust. Do you need to take it word for word? No, you do not. You have to be open. You have to understand what you're doing and add what needs to be there. Remember, a template is just a guide. It is not for you to take word for word and put it out there into the private space. You have to do your own thing internally to your own trust office. So if you find that you have a trustee that is looking to come into your trust office and you have a unique skill set that you want them to do, and you want to list all of the instructions as to what they can and can't do, well, sometimes that's going to look a little bit different than what I provided. And feel free to go ahead and change that. All right. So please don't pay attention to all of the sections in red. Obviously, the ones that are in red, you must change. But there are going to be other areas that you have to add for your unique trust office. All right.
All right, that's all I have for the online questions.
All right, great. All right, so let me go back to the front. We got a few hands raised.
But I could also I could take some questions from the chat whenever you need me to.
Please scan.
I can read them out loud. Yeah,
you scan through that. Let me take two people who have their hands up, and then we'll go back to the chat. All right, so let's go to Jackie Crawford. You are unmuted.
Hello, Avery, Nancy, and everyone. I have a question. I paid my house off with a 1099, and they accepted the 1099A, but then I found out later on they did a non-judicial foreclosure. So what I did, I took the house, I put it inside of my trust, and I want to know if you could advise what else could I possibly do to stop this? Also, I'm sitting on a check for 21K because I had a fire here last October. What they wanted was for me and my husband to sign the check and turn the check over to them, which we have refused because we've paid the house off and I filed everything in court. What I have not done though is did a civil case against them just yet, hoping we can resolve this and to come to a conclusion, come to a finale. But this is supposed to take place between March 1st and March 7th.
Okay.
And I was hoping to speak with you a little more privately about this to get some advice.
Okay. You stated that you paid off the property with the 1099.
Yes.
Would you mind sharing what that process looks like?
What I did a 1099 online through the Treasury.
Mhm.
And when I did it, I filled the paperwork out and I used the Treasury to send an email to him because they will track for anybody's email in the States. And also they will send it to them via USPS.
Okay.
So I did both of those. And as a matter of fact, there was one time I left one of the zeros off and one of the people from his office were letting me know that I needed to redo it. I redid it and they told me that they had their legal department working on it.
Mhm.
And he accepted it. I fixed it and he accepted it. I also sent a rescission letter with that and also a 1099-C for dischargement.
Mhm.
And then later on, I found out that New American Funding had contacted, what is the name? McCullough, Raymond, Liebert, and Pierce here out of Georgia to do a non-judicial foreclosure. So I'm going to stop them. I'm going to go after their surety bonds. Because first of all, we all know that United States has been in bankruptcy since 1933. There is no money. You've got the money when you gave the keys up because of the trust, the CSQV trust. And I just want to do everything I can to stop them. So
Okay.
that's why I wanted to ask you. And also, when I started with you, I was paying the $25 to get in, but I want to know, can I pay the difference to switch over to a junior class?
You're charged every month on a 30-day cycle. So whichever class you went into, you need to allow that cycle to expire before you upgrade or downgrade.
Okay.
Because Patreon is a third-party servicer. I can't do much with how they're processing everybody's credit cards. So just stay in your course for the 30-day cycle. And on the day 29 is when you can go ahead and switch it out so that way you're charged on that day.
Okay.
Now, you are familiar with UCC, correct?
Yes, I'm filed in Georgia and Florida.
Right. If you can, to help you with your case, you're going to have to show that whatever instrument that you paid and used, that it was actually tendered and used and they cashed it, whether they are not trying to honor it or whether they cashed it and put it into the statement of accounting and they reversed it. That is where UCC 3-603 comes in, where they've taken tender of payment and they've accepted it. Now, if they reversed it, there's nothing they can say about it. They honored it because they did an actual exchange. That is really your only thing that you can utilize as far as your payment here, because you don't have the actual deed in your hand for a mortgage satisfaction. Now, you can argue with them all day long in court that there is no money, but there is money. Okay, there is money. There's a public side and a private side to the dollar bill. It is just up to you and how you use that dollar bill. Okay, so we can talk about this more in private because we'll need more time. I need to see exactly what you submitted when you state 1099s and you state that you submitted the EIN numbers and all of that. All of that has to be accurate. And there has to be other IRS forms to go along with that. So we may need to just take a look off the record, see what's going on.
Okay,
Okay,
thank you.
you're welcome. All right, going to Robert. How you doing, Robert?
Good, Avery. How are you? Can you hear me?
Yes, I hear you. I'm doing well, thank you.
Awesome. Sorry for my technical difficulties last week. I apologize. So week 2 member, just want to first start out and thank you for your service, and especially the way you set this up. It's been super beneficial the way the Q&As are laid out. That way, you know, people like myself that come in obviously after the fact can get a lot of our questions answered just by listening to the Q&As that are ongoing. So I'm currently in the teetering between the freshman and sophomore class, and I think February of last year for Q&A. My question is, I'm working with, for context, I'm working with Nancy. I'm getting a possible sole trustee established with you. But for my wife and I actually both. So we're going through this process simultaneously. My question was, so we have a couple of different rental properties, including our primary residence and a couple of different LLCs. And we're both the owners on those properties as well as the LLCs. So when it comes time to actually put those in our trust, would we put that into our marriage contract trust that you talk about, the third one, or how would we split that up?
Good question. When it comes to real property, you just have to decide. It's not about who is currently owning the property right now, because nobody wants to be an owner as far as personal liability, which is why we give it to the trust. But what you really have to ask yourself is which properties are going to forever be rental properties. Do you plan on ever selling them in the future, near future, to pull out the equity? Do you plan on doing any type of refinancing with those properties to pull out equity? And then which properties are going to be in the trust forever to be passed on from generation to generation? If you have current residences that you're going to live in and you do not want to sell these properties at all, you want to move it on to your next generation, then yes, you can quick claim the property over to the express trust. Properties that are considered rentals, Airbnbs, commercial properties for lease, I would do a land trust and then have your LLC sign off as the trustee in that land trust. And this is where in that LLC, you can have the express trust be the sole member of that LLC.
Why don't you go in there and let me listen to this? Thank you.
Let me go ahead and beat that one up. So you can set up your sole express trust as the sole member of that LLC. Make that LLC a trustee of your land trust for those rental properties. Now, in the land trust, you can state who's the beneficiaries. The beneficiaries can be that third marital trust for you and your wife. Okay, hope that answers.
Okay, yeah, it does. I understand. Thank you. So in the past, you've talked about putting together a marriage webinar. Obviously, I'm not just starting, so I'm not sure if that already happened, but do you talk about or have you already gone through somewhere in the course how to separate everything when it comes to that third marriage contract trust?
Yes, well, I haven't done the marriage webinar yet, but I have touched on it sporadically throughout other webinars. One in particular, you can look at the trust certificate unit. That one is on YouTube, and that one is here within Patreon. You'll see how we are making those connections. So when that marriage trust webinar comes out, you'll have an idea of what we're talking about and where we're going with that. For now, just get your individual trust together, get your wife's trust together, and that way you'll be ready for that third marital covenant bond.
Awesome, thank you. And I just have one more question, if I may.
Sure.
So I currently have my ABC injunction, and I just got called in to get my 98 number this week.
Congratulations.
And Thank you. Actually, like I was saying before, the Q&As really help. It's a little nerve-wracking initially when you're not, when you're obviously new to the process, but it really provides a lot of confidence, the way the Q&As are laid out and all the questions that, people have asked in the past. So I really appreciate you and everybody else that was in that initial group. Definitely helped along with that process to make it easier. But so I have those three taken care of for my wife and I both. And we, like I said, I don't have the sole trustee yet, but technically, would you say that you can kind of go all the way to the trust enterprise creation EIN without the sole trustee? So that would include the domestic entity, and then the 8832 reclassification, and then the trust enterprise, I believe it is.
Yeah, that's the process. After you get your 9(8), now you have something to reclassify all of your entities into. So you're going to get your domestic estate. You will convert it into a foreign estate by putting that under your 9(8) number. And then you're going to get your trust enterprise EIN, and then you'll reclassify that under your 9(8) number. So your trust enterprise is mainly used for banking purposes here. Whether you're employed or self-employed, you can have all monies from any source go into that trust enterprise bank account, avoiding the tax reportings that the banks will do, because that EIN number is under the laws of TEFRA. So yes.
Understood. So because those EINs are all domestic, you actually don't need a sole trustee for anything in that tier, I guess you could call it.
Yeah, you only need a foreign trustee for your 9(8) Express Trust. But everything else, your trust enterprise, it can be you, it could be anybody that has a social security number. That's what it's for. It's to operate in the public. Banks, they do need these insured numbers like a life insurance policy. That's the only way that they can do their day-to-day transactions. We've tried, in the past, we have done it where we took the 9(8) number and opened up a bank account as a non-interest bearing account. And I'd say about 2 months later, they shut the account down and there is no way to get that money out. So I do not want you guys to do that process.
And during the creation of that trust enterprise account, you would just sign up as a co-trustee?
You can sign up yourself as a trustee, or you can bring in someone else that you want to be attached to that account that you trust, and they can be a trustee right there.
Okay. Thank you, sir. Appreciate you.
You're welcome. You're welcome. And thank you guys all for participating. It really does help all of the members here get their questions answered. When you guys go into Patreon, if you guys want to go back and check the version 2.0 for the freshman class, you'll see that I recently called the IRS to get a fresh 9(8) number for none other Mr. Thomas A. Anderson. So you guys know who that is the alias in this new 2.0 version that we're using as our example here. So great questions, Robert. Thank you. I'm going to Lisa. Lisa, how are you?
Hey, I'm doing good. Thank you. I did ask this question before, but not all of it, I think, because I'm finding out that as far as owning property, I had mentioned I own property, but I don't own property in the state I'm in. Is that okay if I own other property and I use that when I file everything, or do I have to have something in my state?
Well, county clerks are not going to record your trust files if you're talking about claiming real property in your trust files. They want you to file those documents in the county where that property is located. So if you have property out of the state, then you're going to want to draft your documentation to fit that property's location.
How can I'm not willing to fly to Ohio or Illinois where my properties are to go to the county recorders.
Oh, we just do it by the mail.
Oh,
You simply go to Google, pull up that county's recorder fee schedule and figure out what it's going to cost per page. And you send in your documentation with the money order made payable to that clerk, and they will record it for you.
oh,
And they'll give you the original copies will come back to you. So now, once you've done that in that state, now all you have to do is bring that state's information, that jurisdiction into where you live to protect yourself by full faith and credit. And you do that by simply filing a DBA where you live.
okay. I have done a couple of DBAs already.
Great, great, good. That's all you got to
Okay.
do. If you want to use your property, just file it in the county where that property is located.
Cool. And where do I find what the difference between a UCC 1 and a UCC 3 is? I don't understand the difference, and I was just wondering where I can find that to look over that information again.
Good. In between the freshman and junior course, I've read the actual UCC law that shows the difference between what a UCC 1 does and a non-UCC. But I'll quickly tell you here. A non-UCC is filed in what's called the organic public record. And that is all that can only be found inside of the counties, nowhere else. So when you file a non-UCC in the county, that is the initial lien on which whatever property you're trying to have belong to your secured party. So you file it in the county first, that's a non-UCC. When you do a UCC 1, which they call a financing statement, that is just a notice of what you did in the organic public record. This is why when you hear everyone out there talk about secured party creditor process, they only mention a UCC 1. They are mistaken. That has no power. UCC 1 is just a notice of the real power. But if that UCC 1 is not referencing that which came before it, then it has nothing to do with your process, and it will do nothing for you in court. Nothing. So please, non-UCC is first. UCC 1 is second. In states like Florida, they don't have a Secretary of State that allows you to do a notice of lien. Instead, you just do it online. It's called FloridaSecuredTransactions.com. Now, I'm saying this to you all because sometimes if you do this process in your state, you may find issues with the Secretary of State. They're rejecting your notice of lien. Well, guess what? It doesn't have to be subject to just where you live or the state where you filed your non-UCC in. You can file your non-UCC where you are and file your UCC 1 financing statement in Florida. Any state can accept a financing statement. I'll give you another example. If you were to buy a house in Texas, they are supposed to file your house as the collateral with the promissory note, and they are supposed to file themselves as the lender, secured party, with you as the debtor on a non-UCC in the county where you bought the house. But they don't do that because they know they didn't really give any valuable consideration to purchase the house for you. So because they haven't done this, they give you an out. And this is where you can do this process. But the point is, you will never find a bank file a UCC 1 against you because they don't have the right to do it. You're the one who created the money by your birth certificate, giving you a social security number to then create the security on that 1003 application. Okay, so file your non-UCC where you are, and then file your UCC 1 in whatever state you want. Do it in all 50 states if you wanted to.
I am in Florida, so that's good, and I will. Thank you for that good explanation. I appreciate it.
No problem. You're welcome. Paul Phillips, how you doing?
How you doing today, Avery?
Doing well, thank you.
Good. Just wanted to let you know a little bit where I'm at in the process and what questions I have. If it gets too distracting, I'll move on and answer them later. But so far, I've got my DBA. I mean, not my DBA, but I've got my EINs from my Express Trust, my trust enterprise, and my estate. I did file a quitclaim deed to the Express Trust for my house. And as far as the Express Trust is concerned, are there two trust documents needed, or does the estate, I'm not the estate, but the Express Trust enterprise, that just comes under the umbrella of the big one, right?
Correct. It comes under the umbrella of the big one. So if it was me and I wanted to put my house in the Express Trust, simply do that with a quitclaim deed. And sometimes the clerk is going to ask for a copy of the trust just to verify who are the parties, to verify that you have the right to do this. So when you bring them a copy of it, it's going to show that you are the settlor of that declaration of trust. It's going to show who's the trust protector, who is the trustee, and who is the beneficiary. Hopefully you already have that your trust itself is the beneficiary. Now, Express Trust, what you can do with that. It is my goal and everyone's goal who is into asset protection to keep their name off of the public records. Still control the asset, but not show that you own it, so that way you keep yourself off of the record. If you are using your Express Trust, which has a foreign trustee, naturally the clerk is going to say, well, where is the foreign trustee to provide their signature and sign off on all of these documents here in the court, in the county? If your foreign trustee is out of the country, then that can't happen. So you need an authorized representative to do this for you. This is where you can use your trust enterprise to be a second trustee just for the quitclaim deed process.
Okay, I've actually already got a recorded quitclaim deed, so they did record it.
Great, good. Yeah, so
Now,
your Express Trust enterprise is just simply like you said, it's under the umbrella of the Express Trust.
okay, and to complete that transaction, if you will, about the turning over of the house into the estate, is that done through the UCC?
Yes, non-UCC.
The non-UCC, okay, so once that is done, they recognize it. And then as far as the tax protest or whatever you have to do, how does that work?
It's based off of your quitclaim deed, so you want to make sure that you used something different than fiat currency for the actual valuable consideration. So I recommend 21 silver dollar coins. That's going to allow you to contest with your county assessor, stating that you used monies in species versus fiat currency. So therefore, they cannot value your home on the same level as your neighbor's house, because the only way that they can give you taxation is based on the assessment of what you're willing to pay for a certain piece of property. And this is where the entire market comes in. So if you don't mind, your property is put into this trust because you do not plan on selling it in the future. You want it to be completely yours in total fee simple, absolute allodial title without having to pay property taxes. The only way to do that is to take it off of the market. Okay, so it really just depends on how you structured your quitclaim deed. The language is in there. You should get a hearing to take place with the county assessor. They have applications that you can fill out to do a hearing for a tax assessment. And this is where you show all that evidence in front in a private hearing in order to get that taken care of.
Okay, so what I've done so far with the quitclaim deed, they should come back and respond to that in some way, like send me a final bill to my name for whatever taxes is due up until that sale, if you will. And then after that, then you can test it when they send a tax document to the trust.
Correct. You are going to get something in the mail about that. And if you don't, then you can start the process on that assessment. There are forms for you to start your application to reassess the property.
Okay, sounds good. And I know I'm going on a little bit, but as far as the trust is concerned, there are three of us involved in the family. It's my wife and I and my daughter. As far as who does what, as far as the officers of the trust, what would you recommend? I have already gotten my foreign trustee from you guys.
Okay. In your one trust, you are the settlor, you're the trust protector, you have a foreign trustee, and then you have your beneficiary, which is your trust. So everything is fulfilled when it comes to your express trust. Now, if you want to create a second trust that involves your family, I recommend that be the trust enterprise.
Okay.
Now, in that enterprise, that's where you can list up to 2 people to be the settlers. That means 2 people come together and they provide the actual assets to be held in this trust. The trustees can be a multiple of people. You can have first trustee, second trustee, passive trustees, active trustees. You just wouldn't have a sole trustee like you would in your express.
I see. Now, is that another document that I need to create, another trust document, or it just comes under the when you create the enterprise?
It is
How do you-
another trust document. It's separate. And
Okay, is
it
it the
will
same
have its
format?
own EIN number as well, too.
Yeah, I've already got the EIN number, but do you create another, a very similar document to the first one?
Yes, you do.
Okay, so I can use that same format.
Yep, you could.
Okay, sounds good. Well, that's great. I may have another question. If we have time, we'll come back.
If we have time, yes, I'll come back.
All right, thank you.
All right, you're welcome. All right, we're going to Jesus. How you doing?
Hey, what's up, Avery?
Hey, doing good, man.
Happy Saturday. Happy Saturday to everybody in the chat. Real quick, Avery. So I'm doing a little homework on my side. Regardless of what I'm going through. I got a notice of adjournment and rescheduling. You know what happened in round 1?
Mhm.
Slapped them up. And it's funny that I got this notice about 2 or 3 days ago. I didn't reach out to anybody. I just put my big boy pants on. And I see that the officer, he signed the notice of adjournment and rescheduling, and then they dished it off to another judge. So it was an officer and a judge, right?
Right.
They got rid of him and they threw a lady in there now.
Mm-hmm.
And it's funny because it says, so recommended to the court by the hearing officer, John Doe, and he signed this paper.
Mm-hmm.
I really don't like him, right? So anyway, they dished it off to another judge. So what I did was I did a little studying on my own, and I was running around doing this FOIA thing, Freedom of Information Act. So I'm calling the clerk building. They don't know what I'm talking about. I bounced around for like 2 hours. And then finally I got someone with some type of knowledge, and they were like, no, it's called an OPRA, which is an acronym for Open Public Records Act.
Mm-hmm.
I didn't know that. It's something I learned yesterday. So they don't call it a FOIA. They call it an OPRA, Open Public Records Act, as opposed to Freedom of Information Act. So I'm going to get the oath that this judge swore into, and I'm going to get his too, and I'm going to attach it as my evidence and, do the exhibit things and all that. Am I on the right path? Just to play?
Well, let me say this. In that first hearing, you have to see that that was all about trying to fill you out as to what you know. Once they figured out they know what you know, and you're going to stick to that, yes, they have to change judges on you and get you out of the administrative department and moving you into an actual court of record, which is an Article 3 court, according to the Constitution. So you can obtain these judges' oaths and their affirmations. And when you do get it, you need to be able to understand what you're reading. If it doesn't say anything according to defending the Constitution or the Constitution of the United States, then they are still administrative officers. That means that they were hired by the ones that you need to talk to. So here's what I recommend you do. There are still motions and documents that I'm drafting to give to you for this case.
Like
You will find out the judicial council that sits above the table, so to speak. The judicial council is what controls all of these administrative judges and the ones that have hired them. They need to be CC'd in these forms that I draft and give to you. When you do that, you don't have to say anything when it comes to court. You just show up and say, have you taken acknowledgement of the docs that has been served to all the parties? And you don't move forward until they give you the right discovery. And if they don't give you the discovery, you just keep on saying, I object. On what grounds? They never answer you. They may push you out even further for another court hearing. They may even change the case number. When you see behavior like that, you're going to win the case. Because this is about protecting national security here. They cannot give the answers that you're winning on the record for you to use it as precedence and just go to the mountaintops to tell everybody.
they don't want that.
They're not going to do that.
No.
Okay, but I can assure you, you're not going to be garnished. You're not going to have any statements come in the mail because you're hitting them before it starts.
Oh, 100%. My mind is it's already done. It already happened. It's manifested. So basically real fast. So then my job on my end is to make sure I thoroughly read the oath that judge took and make sure it states anywhere that they have to defend the Constitution. If not, then I go to the higher ups, the judicial council
Yep,
that controls them. Am I correct?
that is correct.
All right, so when I get that oath, I got homework to do. Here's the beauty of it all. I got about 50 days. That's like an eternity. So this is gonna be fun.
Yeah, that's typical standard what they do.
Yeah, this is just, it's like giving Batman prep time to, be
Mhm.
Superman.
Exactly.
All right, so I would like to email you the new summons. You're busy. I'm not rushing you on it. I'm just gonna email you the new summons, right? So you can see like their signatures and whatnot. I'm gonna do what I gotta do on my end.
Right.
And then we'll touch base in a week or two. By the time you even touch base with me, I'm gonna be on another level. So
Right. And you know exactly which email to send that to.
yes, sir. Yes,
Right.
chief. Now, real fast, before I let you go, hold up. This is something so when I couldn't get the FOIA, right? And then finally I found out it was called an Oprah, and then I already printed it out and I'm going Monday. I'm gonna pay the fee up front. Because she was like, oh, you can do it online and you'll get it free. I'd rather go in person, pay for it because I want like a copy from them, certified, authenticated, you know what I mean, to hold more weight and whatnot. I was having an issue, so my brain started going off, and then I ran across 28 U.S. Code Section 453, which is the oaths of justices and judges. Can you bring that up on your screen real quick, Abby, for everybody to see this?
Sure. What was that again?
28
Mhm.
U.S. Code Section 453. I don't know if I'm bugging. I don't know,
Let's see.
but this is. Let's scroll down. Let's just reading something.
All right. Each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I, such and such, do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as blank under, that can mean judge, magistrate, whatever, under the Constitution of the state and the laws of the US Constitution, so help me God. Now, if I were to use this, I would use where it came from, right? I wouldn't use this here because it's copywritten. That's how they get you. Now, it's coming from this actual public law, 101-650. This is how I would reference this. But where is this public law coming from? You guys know it. What articles does that come from?
Are we gonna do the?
Articles of Confederation, right? We go down here, it's going to talk about what the judges can and cannot do. Let me do a quick word search and type in judge. The top here. Somebody knows it. We went over this many a times. What was it? It's actually inside of your injunctions, where it talked about the judges has to protect the treaties, and it must protect the Constitution in the state and the Constitution of the United States. Let me do that. Just type in treaty. There it is.
As Marrakesh and Tripoli or something like that.
Correct. No state, without the consent of the United States and Congress assembled, shall send any embassy to or receive any embassy from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state, nor shall any person holding any office of profit or trust under the United States, or any of them accept any present emolument, office, or title of any kind whatever from any king, prince, or foreign state, nor shall the United States and Congress assembled, or any of them grant any title of nobility. Now, then you go to the US Constitution, Supremacy Clause. Go back here. Right here. Supremacy Clause, Article, what is this number here? Is that 6? 6, Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and who? Judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. So when you use the Supremacy Clause, once you find their oath to back it up, and then you add the treaty that you want them to respect you by, and I'll give you a hint. That is the Treaty of Algeciras. That is the Treaty of the United States and the Sultan of Muscat. And that is the Morocco Treaty of Peace of 1836. Those are the treaties that protects all of you here in North America, to have these judges protect you and not act partially. Very, very good find. So now when you get that oath, you know how to connect it.
And that's why on my DBA, I have, when it says purpose, ministerial purpose on the treaty with USA.
Exactly.
Nice. Now, can you bring that page up real quick? This is what I wanted to tell you about. And not
Yeah,
the Cornell one.
let me get to Isaiah for the chat, and then, like I said with Paul, we'll come back and
All right,
we'll
thank you,
pull
Avi. I appreciate you. Happy Saturday.
that- Yeah, well, if we can come back and pull it up, we can do it.
Okay.
All right. Isaiah, anything in the chat?
Yeah, we got a few questions in the chat. We got a question from AJ. He says, you mentioned in one of your videos about not owning a farm because it constitutes doing business with the government. Could you explain?
You can own a farm, but it's just how you use that farm. If you're in a trade or business with the United States, where you're, entering into agreements as far as producing vegetation or cattle, and you're a part of the slavery cattle industry, something like that. But you can have farmland. Anybody would. I think all of us should have farmlands and grow our own food. For sure. What else do we
Right
got?
on. Seti says, after the ABC with your birth name, but had a name change, how do you reference both names in the trust and all paperwork?
Okay. So if you change your name and then you took that name change and placed it on the birth certificate, which now makes it a new straw man or new ins legis juristic person, same way you would your first name. So you can still authenticate that birth certificate all the way up and then place that inside of your trustee minutes and put it on a non-UCC. Now on the new name that you do again, which is not going to have anything to do with adding it to the birth certificate or the Social Security Administration, that still needs to be placed on a DBA and inside of the copyright infringement agreement. But you will essentially just keep that private, turn it into business credit, your new title of nobility name, set it up on Dun and Bradstreet, build business credit. There are a few members here within Telegram that specialize in that to help you build business credit with your title of nobility name. So that way you can get credit cards and travel the world with that and not have to use your straw man's Social Security information for that. But yeah, that's how you do that. You still got to connect it the very same way you would your normal birth name in your trustee minutes. All right, anything else?
Oh yeah, there's plenty. Mark asks, what is the point of some trusts being trademarked and patented?
One more time.
What is the point of some trust being trademarked and patented?
I would say, well, for one, people are getting unique with their trust name selections. So you want to make sure that they don't accidentally pick yours. But I wouldn't really care about trademarking the trust name. What I would care about is trademarking the names and all of the other businesses that the trust owns. Do a trademark that way. All right.
All right. Erica D says, is Seminole County a county that is recording trust no matter what the state and county is that the trust property is located in?
Yeah, it's just like what we told Lisa. If a trust property is in a county outside of Seminole County, then you will not be able to do that. In Seminole County, you have to do it where that property is located. So do it there where the property is located. If you're having problems with that, then you can take it to Seminole County, but you do not need to have a piece of property to record your trust in Seminole County. What we're doing is we find that when I did it with gold and silver, no problem. And then I did it in another county in California. They said, nope, can't do it. So I gave them real property. And now you guys are coming to me all over continental United States, and they're giving you problems with your property. The one thing that they can't refute you on is business contracts and bonds. So I will show you in the sophomore class how to get the bonds and put these things together, so that way you can record this in any county without any problems. So if you want to wait for that to kind of see and compare, if you want to just move on and do it with your current property in your current county versus what I'm going to show you with the bonds, then hold off on it, no rush. But I just uploaded version 2 for the freshmen. That's in the system right now, and the sophomore is coming, where you will see how to do the bonds. All right.
All right. Queen Day says, isn't there a law, or used to be a law, that states if a negotiable instrument is tendered but not accepted, it must be returned in 3 days, or it is considered accepted and the debt is discharged?
Yeah, we were just talking about that with Jackie. So I pulled it up. It was UCC 3603. So let's look at that. It says if a tender payment, right? Let's say you're using one of the treasury checks that you see in the senior class. Let's say you decide to draft your own promissory note and give that to them. But hey, there are some elements to a promissory note that you really, really need to know what you're doing before you do that for it to be effective. But let's say you did a accord and satisfaction, money order, cashier's check. That's all considered a tender of payment. So let's say if a tender of payment of an obligation to pay an instrument, say a mortgage or installment sales agreement, is made to a person entitled to enforce the instrument, which is the bank, the effect of tender is governed by the principles of the law applicable to tender of payment under a simple contract. All right. B, if tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, the bank, and the tender is refused, there is discharge to the extent of the amount of the tender. So if you have a $500,000 house and you sent in an instrument for $60,000 and you wrote accord and satisfaction and they refused it, that means they're supposed to apply the extent of the amount of the tender, which is 60,000, to your account. So now you owe $440,000, not 500. That's all that means. But if you were like someone else who did a treasury check and you did it for the full amount of the mortgage, 500,000, and they refused it, then now it's going to be discharged to the full amount of the obligation. So it all depends on the amount that you've placed on that document or your instrument. Let's look at C. If tender of payment of an amount due on an instrument is made to a person entitled to enforce the instrument, the obligation of the obligor to pay interest after the due date on the amount tendered is discharged. If presentment is required with respect to an instrument and the obligor is able and ready to pay on the due date at every place of payment stated in the instrument, the obligor is deemed to have made tender of payment on the due date to the person entitled to enforce the instrument. So obviously, B is where everybody would fit in. And you can also go and read the section before this, 604, after this, discharge by cancellation or renunciation. This one here falls more in line with 15 USC 1635, where it's the rescission of signature that we talked about previously. All right, so I encourage you, Article 3 is going to deal with everything that you need to understand when it comes to discharge. Right? What else do we have?
Shayna asked, uh, can you do a video on investments like life insurance, property, etc.?
Intriguing. I could, but I think I would not be doing justice. I think IBC Global has the best content out there when it comes to life insurance investments and how to use it. Go to YouTube, IBC Global, and yeah, Mr. Parisi, he's really, really good at that. But of course, eventually I will start showing some things, but he's got a lot of information on it, and it's I study it, put it that way. Anything else we got in the chat?
Yeah, like I said, there's plenty. Lisa asked, when will you do a foreign tax credit class?
One more time, when will I do a foreign tax credit class?
Correct.
Most of these questions in regards to taxes will not benefit you all until you've completed your process and fully understand what you've done. So I am keeping track of that as to who are complete, what you've done, and what you would use that information for, because it's very, very complicated. At the same time, you want to make sure that people are not abusing that information, because they can hurt themselves. So that is going to be on a case-by-case observation. But we will do it. We have to do it. That is the end goal here. Let me go ahead and open up one or two hands here, and we'll get back to the chat. Going to Frenchie.
Hi, everyone. Happy Saturday. I have a question regarding still filing my taxes under the trust. I have a hard time. Everything is prepped by my accountant. I just have a hard time finding someone knowledgeable to file under the trust. Any suggestion, or someone that you know, or someone in a group that is familiar with the process that we are doing and filing taxes under our trust with businesses, of course.
Yeah, me.
Yay! Okay. Okay, so I'm gonna need that. So I know we have a consult on March 1st, so I guess I can't wait until that time unless there is something that can be sent to me so I know what to do.
I can send you something to give you an idea of what you got to do.
Okay. My accountant prepped everything. It's just, he's like, I don't know. So I'm not familiar with that. He said he's going to try, but the try part, I'm not for it. So
Yeah. I think where most CPAs are lacking information is when it comes to how tax havens utilize copyrights, royalty payments, 1099 miscellaneous, those kind of things.
okay.
So if they're used to only doing the white forms and not the red forms, that will cause some confusion for them. But,
Yes.
once we have our discussion, you'll clearly see like, oh, well, I can explain that to him and he should have no problem going forward.
Oh, okay. All right. Because he's not against, trying. It's just he don't have the knowledge of it. So, but I don't want, to just be like the guinea pig for him.
Right. Exactly.
So, okay, then I'll wait for you to get back to me on that, or we can talk about it during the consultation schedule then. And then I updated everything for my court case in March. So I email it to you. Just if you have a moment, just to triple check that everything we did together is fine and I'm ready to file.
Okay, I will.
Thank you so much.
You're welcome. Thank you. Thank you, Frenchie. Going to Mike. Mike B.
Hi, Avery. Thank you for taking my question. Good morning or good afternoon, everybody. So my question is around 401ks. I've got a 401k with my current employer, and then I've got a 401k from a previous employer that I've converted to a gold and silver IRA. What's the best way for me to handle them with the trust or even take control of them so I can invest them privately?
Mhm. And the 401k, is that directly in your birth name or a business?
Birth name.
Okay. And who is the current broker or holder of these assets?
Okay, that would be Fidelity. And
Mhm.
then for the gold and silver, it's an equity trust company is the
Mhm.
fiduciary.
Mhm. Okay. All you got to do is provide a certificate of trust for your enterprise and give them a W-9 telling them that you want to transfer that over into a different entity that you control. So that will be your enterprise, and it's going to show that you are the trustee and the settler, or sometimes you can use your foreign trustee as the settler of that enterprise. Give them a W-9. It's going to have your trust enterprise on there. It's going to have your trust enterprise EIN number. Let them transfer that over. That's going to remove yourself from personal liability and place it into the trust. That's a trust that you have complete control over. I want you to use the enterprise because that allows you to open up a bank account, to where you can control that. That's the best way to go about that. Now, if you do it correctly, according to the course, it's going to be under the laws of TEFRA. It's going to help you to avoid the tax reportings from the bank to the IRS. There's still an extra step that you have to do, which is that entity reclassification process on that EIN number. Now,
And I've got that.
Good. Now make sure you list this inside of your minutes. You want to make a fresh trustee minutes, and you want to list discreetly as best you can the details of these assets inside of your minutes. I would love for you to, anything that you have as far as property that you put in your minutes, please do the best you can to do what's called a recording down in the county. So if you already have done your trust recording already, all your minutes going forward will be upon what's called a UCC3 in the county. Everything that you add into your trust will be a UCC3 because that is considered a literary work. If you publish it down in the county, it's a published work. And all you got to do is go into your constitution. They tell you what type of activities will give you tax exemption from property taxation. And that is charitable work, religious work, education, literary works. If your trustee minutes are published down in the county, maybe even as far as going inside of the local newspaper with this minutes, then now you have something to show this is an actual published work. So you avoid taxation on the state level. All right.
I'm actually recording my trust next week. I've got everything lined up. So I will just need to add that UCC3 then.
Yes, you would.
Where
Now,
do you
some
have?
counties are hip to that. Some counties don't fully understand UCC3s. All they care about is the UCC1.
Right.
If that's the case, then just use a UCC1 and make a new recording on a UCC1, but you're referencing the previous ones to connect the dots. Okay, that's all you got to do.
Okay, that's awesome. Thank you so much.
You're welcome. All right, go to one more, then we go back to the chat. Isaiah, going to Brad. How you doing, Brad? Just got to unmute your mic.
Hey, Avery, how are you today?
Doing well, thank you.
Appreciate everything you're doing. My question is in regards to, well, first of all, I'm a freshman, but I've listened to a lot of your real estate stuff because that's my field. And I do a lot of creative finance, particularly sub 2, where we take over the mortgage. So in that case, we would go onto the warranty deed, and the deed of trust for the mortgage would stay in the seller's name. I'm sure you're familiar with it. The question is, how does that affect the two different ways we're looking at discharging here, whether it's through treasury notes or through the South Dakota laws of discharging after 2 years of honor?
Are you doing anything such as wraparound mortgages?
I do that as well. Yeah, we call that an agreement for sale or a contract for deed.
Right.
So and I think that's kind of what you were referring to in some of your work. So we do it one of two, well, there's probably three ways, but one is you take the deed on a sub two, and a lot of times the equity is so small that, we just give them like $5,000 to sign the deed over, right? And then if they have like $100,000 in equity, then we'll just do a contract and wrap the whole thing and then pay the title company. The title company pays the mortgage company and pays them the difference.
Right. Okay.
So just wondering if we were to go out and grab a bunch of these houses in the upcoming market, if we'd be able to apply the discharge, technology that you have.
Yeah, and just know that it's not guaranteed. They do it when it's in their best interest to do so. Anyone can discharge. You didn't have to necessarily be in the rightful standing to do that. As far as being on the deeds for acquiring property, I can simply pull up a list of properties that are, to be sold within the county for the tax liens and shoot out a whole bunch of, treasury checks just to get them discharged on behalf of the people if I wanted to. So
Oh, wow.
I don't necessarily have to be attached to the property. Now you will get you will get higher standing over somebody like me because you're actually on the deed. Your company is, or your trust is. So that means the equity will go directly to you if they process it.
So you could provide like a business service for foreclosures where,
Oh yeah,
depending on what the seller wants to do, if they've got a family and they have to stay in the home, we could just provide a service of getting a discharge, or if they're already out of the home, maybe we could take the deed and split some equity, do things like that.
that's basically creative financing. Yeah, you can do that. But the
All
issue
right, man.
is there's a time limit. If these people are in foreclosure, that's going to be kind of tricky. So it really is all about timing. I'm sure you know that with real estate.
Yeah, so if they're in foreclosure and they have arrears, I guess, well, even with arrears, that's okay. We can still do this. It's just, can we get it done in the time before we need to hit them like at the notice of default. So we still have like 90 days. Would you agree?
Right. Yep.
Cool. Well, I'll keep going along and getting my stuff done, and we'll talk about it further later.
All right, Brad. Thank you.
Okay, thank you.
All right, Isaiah, what do we got?
All right, locked and loaded. Jackie asks how to file a non-UCC on the floridasecuredprocess.com.
It's so simple. It's really so go to floridasecuredtransactions.com and it's going to tell you to file a claim. You click that and it opens up the actual UCC one and you fill it in exactly how you see me do it inside of the courses. Very simple, but you're not going to, the information that you put in there in collateral 4 is the county recordings information that you've done in your actual county. Okay. It's so simple. It really is. Some of these things I just don't even bother making an instructional video for because it's really that simple. All right, what next?
Right on. So we got a trust enterprise question. Dwayne asks, can I place my business under or in the trust enterprise if my business is an authorized dealer for a specific manufacturer?
Yes, you can. You can also do it for the express trust. That's not going to be an issue. Where it is an issue is, let's say your existing business was started by a partnership. So you may want to consult with your partners because of course, you have to start talking about how you're going to divvy up the monies and who's responsible for taxes and who isn't. So that's an internal question that you have to ask yourself. Next.
Reggie Bay says, can you speak briefly on the 241, 242 lawsuits?
18 U.S.C. 241. That is a lawsuit against officers who have defrauded you, defrauded your constitutional rights, inalienable rights. So you have to be very well keen on your Bill of Rights and your Constitution and how to connect the dots where they should have obeyed the documents that first created your Constitution, which are those treaties that we just mentioned. So you start off with the treaties and you tell them, we understand that you have to protect the Constitution. You have to first protect the treaties, which then spawn and give birth to these constitutions. Your oath says to do that. I accept your duty to do it. Now that you didn't do it, and I have proof that you didn't do it, I'm suing you in your personal capacity under Rule 17. That's how a 241 suit will go about. And, you just have to be very, very descriptive in your statement of claim. And when you do a relief, it's called a demand for relief. You wouldn't do a prayer, so to speak. That's something for attorneys who need permission from the administrative judges. But you're doing a demand for relief, and you have to state inside of that relief what exactly you want them to give you, whether that's punitive or punitive damages, monetary damages, or even just to be left alone and say, look, I want you to put me on this in this do not stop or whatever list forever, do not tax list forever, based on this irreparable injury that you've done against me. And you got to show them that you're not afraid to say that. You're not afraid to stop, and you will appeal if you have to. The more appeals that you do, the more terrified they become, because now you're telling on them on every single court that's above that existing court. So, but read up on it. USC, 18 USC 241, 18 USC 242. And that's what you use. Any more else we have in the chat?
Oh, yeah. So Wendy Dobbs asked, how does one verify identity in iPostal account in order to retrieve your mail? The foreign TTEE is a new person / name I created, not associated with my birth certificate name. I took this information from the book, wondering if I missed a key point somehow.
When we opened ours, we gave them proof of insurance. We gave them proof of being a part of a deed or a lease or rental agreement. We've also, you can provide your passport card, which doesn't have any addresses on there. You can even give your passport card and your passport book as two separate IDs, because they both have different ID numbers. So you can do
Right.
that.
Yeah, to add to that, I would say in my experience, they do ask for 2 forms of ID just to verify your name. And then also it's a revolving door as far as employment there. And let's say you go in there and you say, okay, well, I need you to look out for mail coming in this Express Trust name. That employee may remember, but they may leave, and then somebody new comes in, or somebody new gets added to the roster, and they're not familiar with your Express Trust name or any other name that you would have coming or mail coming to that iPostal account. So you constantly got to remind them, because they will send back your documents if they don't recognize or know to look out for a special name for you.
Right. And that can be very, very annoying. Very annoying. So yeah, let's continue. We got time here.
Okay.
You guys are
John. Okay.
Yeah, go ahead.
Gene Duke asked, after classifying my estate into the Express Trust, do I also need to classify my SSAN into the trust?
SSAN?
Mm-hmm. SSAN.
Social Security Administration number. I mean, I assume that that's what you mean, but no. You've already done it with the estate. To get your domestic estate online, you had to give up your social. And then you converted your domestic estate as a foreign estate by putting it under the Foreign Express Trust. So that covers your social security number. All right, now I've seen one here towards the bottom. If I can repeat the names of the treaties that I spoke of earlier: Treaty of Algeciras, Treaty of Marrakesh, Morocco Treaty of Peace of 1836, and the treaty between the United States of America and the Sultan of Muscat. All right. Now, also, I'm going to do a class on talking about trading with the Enemy Act, which I think is very, very important to discuss, because that ties in with your, what should I say, supporting your discharge for mortgages and auto loans and all of that. If the act is calling you an enemy of the state, and yet the treaties call you something different and how you're exempt from things like that, then that is what you call a true 241 suit. They're defrauding the people when the treaty says do not do it. All right. All right, so let me go ahead and going to Shayna. You are muted.
Hey, well, I need to stop saying hey. Peace, everyone. Thank you. It's been a while that I have been in the chat. So first and foremost, Avery, I just want to thank you for everything you have taught me. It's almost going on 1 year that I have been with you, and I'm very excited. I have a lot done, and I have, what was this, last week? I ended up using the birth certificate, the authenticated birth certificate in my enterprise card, my enterprise actual debit card inside the airport. So I've been wanting to try that for a long time since you told us sometime last year, and it actually worked. So I put it inside of the video. I mean, I put a video, like a quick video, inside of the Telegram, and
Yeah.
I'm very excited for that. So that was awesome.
Awesome. I'm glad you had experience with that. It's kind of unique to go through the whole system that way, right?
Yeah, I was like, okay, I felt like I was a president or something, you know, like.
Right. Well, now we're going to have to take it to the next level. Once you all get your passport with the explanatory statements, with your passport, you're going to get an application locator number. And this locator number allows you to figure out where your passport is being approved or rejected while you're waiting for it. But that locator number stays with you forever. And there is a process with TSA that allows you to invoke the Articles of Confederation and to get what's called a redress number. And when you go to buy your airline ticket, inside of the application, every single airline has a section right below your payment that says enter your redress number. When you enter it, go to the TSA, you give them your passport book or your card or whatever, and then you give them the ticket. Now they're going to scan that and they're going to see it. They're going to see, oh, well, we got to pull you aside over here. And it's almost like you've seen what Clear, that thing, TSA Clear or something like that. But you don't take your shoes off, you don't take your belt off, you don't take everything out of your bags, you just walk through with the stuff on you, and that's it. So it's a little bit better. I like how they kind of take it back to the times of 1972, where you just walk in and you can have a gun with you and get on the plane.
See, that's what I'm saying. When I went, I was like, ooh, I feel like it's like, I know I have to get the passport part. So that's my next thing that I'm doing. So that's my next step that I'm working towards. And I didn't, when they escorted me, I was just like, oh, okay. I still have to take off my shoes and things. So I know I felt like it's something that's going to be better. So thanks for clarifying that, because I like that experience. So I'm definitely about to hurry up and finish this passport part, because, the confidence it gives, my thing now that I'm having an issue with, I listened to you guys previous recordings, when you say, I think it was last week, when Louis asked the question for me for the enterprise. So I have been going inside of these banks, and I have been opening up my enterprise accounts. So with every company, like with every company I go to, they give us their own certificate of trust documents. So I had just, transferred what I have on my certificate of trust to on their paperwork. And then I had like some discrepancies within my Wells Fargo account that they had me as a sole owner of the account. So my thing is, because we have to give, I'm just trying to clarify what also with members in the group. So I'm asking questions for me and everyone. Can you tell the, even though we have the Patreon, but can you like let them know, like they have to give them the social security number, or they can use someone else? Because we're inside the Telegram, we're having a lot of questions when it comes to the enterprise account process.
Yeah, you have to you have to use a social security number. That's the only way the banks are going to be able to do business, opening and closing every day. That social is benefits and privileges of the United States. So it has to be done. Now, just because they told you to use their forms, that's no problem. I don't care about that. Just transfer it over. And when they tell you you're going to be the sole owner of this thing, that's perfectly fine, because in trust law, the trustee is always looked upon as the owner.
Okay.
But you're the manager and foreseer and caretaker on behalf of the actual beneficiary. And so that is the trust itself anyway. So in trust law, terms like that does not scare me away, shouldn't scare you away. If they say you're the sole owner, perfectly fine. If that's what you guys want to call it, then call it that.
Okay. And then with the enterprise building, like for building, someone asked a question as far as with that building the enterprise number. I guess they were trying to use the social security. They was using the EIN of the enterprise number. Let's say she filled an application. She's trying to use the enterprise EIN number to apply as for SSN. When they ask you for a social security number, so she just inserting the enterprise EIN number.
No, that would not work. And if it did work, they may get questioned.
Right.
Wherever they ask for an SSN, you got to give it. Wherever they ask for an EIN, you got to give the trust EIN number. Okay. They have to do that.
Okay, and for the enterprise, this one was the last question. For the enterprise, like what are we using that across border? Like what are we using the EIN enterprise for? We know that we're going to get it for that we have to use it to get the monies from, online and money orders and things like that. We're getting that. So what other ways are we using that?
All things banking, all things, let's say, auto insurance, right? You register your paid off car in the trust enterprise, and you're either going to use yourself as the trustee to get the insurance, or you're going to use someone else who has a current driver's license and, social security number to get the insurance for you as the trustee for that trust enterprise. You're going to use it to handle capital gains for Bitcoin, gold and silver assets, 401ks to be transferred over, all things banking. When it comes to the 98 Express Trust, that is like what's called a holding corp. Everything is below it, keeping everything exempt, removing its tax liability and assuming that person's tax liability because it can handle the weight. It can handle it. So think of it that way, okay? Now for you personally, where you are, where do you need to use this trust enterprise? Is it just for banking? Is it for estate planning? Is it for real estate? What do you think for yourself?
Well, with me, I have to do, well, because I have property and I have property and, I have rental property and I have, other investments that I'm trying to do. Like, I'm glad that you mentioned like the stocks and stuff like that, because that was like my question from earlier. Like, I wanted to go into more details, but it was just like, as far as like investment wise, like that's where I'm at with it.
Okay.
Like, I really want to invest in like the health, because I remember you telling me a long time ago with the ADP, because this is how I normally do my business credit. Like, I mean, with my businesses, I signed up with ADP, and I remember a long time ago you said, just get a health insurance. And I'm like, I'm stuck, like, wait, and health insurance, I mean, not health insurance, the life insurance, I'm sorry. And I'm very stuck. So I don't know like what to invest in right now, and I'm ready.
Right. Okay. Let's talk about life insurance. You're going to give your social security number because the life insurance company is going to require an insured to fund this thing. Right. And they will also ask you who is going to be the beneficiary. This is an important question. Is it going to be your trust enterprise, or is it going to be your Foreign Express Trust? For me, I selected the Foreign Express Trust, but I didn't have to. Maybe a different life insurance policy, I can do the trust enterprise if it's a shorter term, if it's just for, investment purposes or whatever, on a short-term basis that I'm going to use to flip properties or something like that. But long-term, if I want this thing to pay out until I'm like 70, 80 years old, yeah, I'm going to put that into my Express Trust. I'm passing that on to whoever is going to assume businesses that I put together, right? So you just got to think about, what is the life insurance policy for? Think long-term and think short-term, and that will tell you which entity to use as your beneficiary.
Okay, so the enterprise is more of a short term, and the foreign will be for long term.
Exactly, because
Okay.
you have a short-term life insurance policy. That means by the time it ends, payout has to occur.
Right.
So when that money pays out, it's got to go into an account that you can control. You're still alive. So that has to be the trust enterprise.
Okay, and it doesn't matter if we get term or whole life, does it?
I'm a big fan of whole life, but no, it doesn't matter depending on the end goal.
Right.
Right.
Okay, that makes sense. Okay, well, thank you.
All right, Shana, you're
I
welcome.
appreciate you. Talk to you. Can you please, what I had text you?
I'm going to
Yeah.
look at the schedule and see
When-
what we can do.
But thank you so much. I really appreciate it.
All right,
Thank
no
you.
problem. Mhm.
Okay, cool.
All right, Melissa, how are you?
Hello. On the process of putting one of the paid off cars into the trust and registering it with the DMV, putting my mom, because she's just, staying in the, normal,
Yep.
putting her as the trustee. I guess I'm not putting it together in my head. Like,
Mhm.
would it be separate paperwork, kind of like we did with the banking, that we would give the DMV and putting her on as the trustee? Is that kind of how it would be?
Mhm. Is this car for you or for her?
It's my husband's truck. So, because it is paid off. And so like, it's kind of to do for the injunction.
Gotcha. Let me ask this other question. Do you ever foresee using this car to trade in for something else?
No.
Okay. That means right now it has a certain market value. And as you continue to use it, it's going to depreciate. Let's say you get into an accident and the insurance cannot pay out because it's lost all of its value. Will you still fix it anyway?
Well, it's an older truck. I mean, it'll just end up being his shop truck anyway.
Okay.
And at the end of the day, like it's not too old, but it's paid off.
Gotcha. All right. So now that we answered that, Yes, you can put it into your express trust. It doesn't have to be the trust enterprise. I would only say trust enterprise if you had planned on, trading it in or selling it for cash in the near future. But the express trust is really just to exempt it from the property taxes, the annual taxes that you do with the DMV.
Oh, okay.
How you do that is when you go down to the DMV, you give them a copy of the declaration of trust, and you're going to make a trustee minutes that is styled as, it considers all of the information that you would find in your DMV forms for a bill of sale. So your husband will sell the property as a gift to the trust. If they make him put down an amount of money, then let it be $21 and that's it.
Okay.
So he'll put $21 down. Of course, you still give their form for a bill of sale because that's all they want to accept. But your declaration of trust will have its own trustee minutes that has a bill of sale in there so they can see, okay, this was properly documented for the trust. They'll scan it and save it into their system. So that way you never have to bring that in the future. You pay your annual fees to have it, recorded into the trust. They obviously going to want trustees' information. So you have to put your mother's name down as the trustee and put her driver's license down as the trustee. Some
Okay.
states require you to also have insurance information, which means your mother being the trustee, she's going to go and get insurance for that automobile or that truck. It could be whatever liability you want. They just need to see something. Now, your husband, if he's the main driver of that truck, he would definitely need to get what's called non-owner occupancy insurance to cover himself and anybody else while he's operating that truck. So that's a policy for himself. And of course, you're going to be paying the policy for your mom as well. Okay. Now she's not driving it, so that's perfectly fine. When it comes to getting the monies back for the annual dues that you pay the DMV, if you can, look at the actual forms in the DMV where it talks about transferring over from one person to another. There should be a section in there that talks about a lien holder. And the lien holder, sometimes that is listed as the bank if you finance it. But because there is no financing here, you want to state that your husband has entered into a financial agreement with the trust to allow the trust to list itself as the lien holder. Of course, your husband is not making payments to the trust, but on paper,
Right.
that is what it's going to show, and they're going to want to see that. Okay, that allows the trust to be a lien holder. So lien holders do not pay annual fees for the actual automobile. The only one that pays those are the actual debtors. Okay, so that's what you want to do there. And then you keep the receipts of that if you have to pay right now. So that means next year's tax filings, you will file, the trust will file that to get the money back.
Okay, awesome. And then so normally though, for my vehicle, which I'm still paying on, well, I'm currently doing accord and satisfaction, but if I were to sell it or whatever, I would just do that in the enterprise. The trust is where I would register that one.
You mean if you paid it off?
Yes.
Yeah, if you paid it off and then you put it into the trust enterprise, so that way you can sell it and they can issue a check out to the enterprise and you actually have a bank account for you to go somewhere.
Okay, cool. All right. And then on the injunction, so if my car isn't paid off, but we do the injunction for my husband, could we just list my vehicle under his injunction for now?
You can,
Would that be
yeah.
okay? Okay, cool.
Yeah, up to 4 vehicles, you can do that.
All right, awesome. Thank you so much.
You're welcome. Great question. Great question. All right, Isaiah, what we got? Anything?
Yeah, we have quite a lot. So
We work today is what you're saying.
so Mike Butterfield, he's asking about 401ks. Did you already answer this one?
Yes.
Okay. Say service announcement. Mine. Jackie Crawford asks, is there a template for an injunction and non-UCC filing and a UCC 3?
Yes, in previous Saturday classes. So, but if you want to find it quickly, you want to go into the sophomore class, and that's where you'll find that. All right.
Okay. I'm still looking for more questions. It's about 54 messages I'm catching up. If you want to answer somebody else's question.
Okay. I'm going to Nathaniel. How's it going?
Hey, how's it going? So I have pretty much two questions. The first question is I have a friend that purchased your book and they received their 98 EIN and expressed trust. And in that she told me that she had to close out her credit card and her personal credit card that was on her Social Security. And I'm wanting some insight. I am in the freshman class, so I'm in the freshman class. So my question to you is, or also a statement, I have like maybe $90,000 to $100,000 in personal credit. Would I have to close out all of that credit to do this process?
No, you don't. You do not have to close out any of that. Now, I would do the best I can to pay it off, discharge it through many different mediums. That's
okay. Well, sorry. Let me just say this. Let me just say this. So this is last. I don't owe anything. I just have that much credit allocated for me to be able to use.
Gotcha. Okay. No, what some people do is they understand the heads and tails concept of the two-sided coin for the ens legis person, right? They understand the tails, which is the birth name and first, middle, last, and the heads, which is the last, comma, first, middle. That's the creditor side, and then the other one was the debtor side. All of you have experience with this. You've seen it before. You get a credit card offer in the mail. How do they address you? Last, comma, first. And when you turn in your application and they approve you, now they're talking to you as first, middle, last. So there's always two sides to the coin. Now, when it comes to your credit, look at your credit that way. Your trust is going to control both of those sides of that coin. Now, you, as you move forward in this commercial matrix, so to speak, you want to take on a new name. That is your title of nobility name. So once you figure that out, and please, you guys go watch version 2 of the freshman course. I'm really trying to hone in and show you guys how to figure out this new name and how to properly pick that as far as where you're born and your location. So do that. When you move forward, when it comes to this credit, some people have, say for yourself, you got 90,000 available to you that you haven't tapped into yet. If you were to tap into it using your first, middle, last name and your social security number, you have all this credit available to you. Some people have taken that and started building credit on that title nobility name with it. They just did a transfer, right? Take the cash off and dump it in as a secured transaction for this new name that you're trying to build credit with. It's a great way to do it. And then all you do is focus on discharging the debt that's on that straw man's name. You can do it that way. I say that because your trust is controlling the liabilities of both of those sides of that coin. So that way you don't feel like, okay, this is a complete liability on the personal side.
Okay. That's what I thought. Basically having one foot in the land of the living and one foot in the land of the dead, and being able to play on both sides. So thank you for that. I will definitely. I saw that you sent out the other classes for us freshmen. So I've seen that today. I'm going over that. I only have one other question, and then I'm off. Before learning about 0%, learning about you, I was reading The Art of Passing the Buck by Charles Author, Enterprising, and I wanted to know, in this book, which is very concise, they talk about irrevocable common law trust, and but they don't really speak about express. She doesn't, express trust. And I was just wondering, had you had any experience with that in terms of what you teach us?
That you said in the middle, it didn't come through on my end. Can you clarify that last part for me, please?
Okay, I was just wondering, had you had any experience with The Art of Passing the Buck with Charles Author, Enterprises, the book, volume 1 and volume 2?
No.
Okay, because the only reason why I even asked that is because I was reading that before reading your book, and it didn't speak on express trust, but it did speak very highly about irrevocable common law trust, and so that was it. And so, but thank you very much. You said it's the same thing?
It sounds like the same thing. I'll have to check out that book and put that on my list to read. Yeah,
it's very good, and it's 2 books. The first book is $50, called The Art of Passing the Buck, and volume 2 is $700.
Okay.
Because it teaches you it teaches you how to be a trustee. It teaches you every single thing.
Awesome.
The second book is the blueprint of trust. She actually gives you 37 pages of what you will put in your indenture.
Awesome.
Before you even start. So I just wondered, because I know you're so astute and your book is amazing. Had you had any experience? Because I was like, well, she's not mentioning express trust. Is it the same? I mean, the express trust is a common law irrevocable trust. Maybe she's talking about a trust enterprise, because I keep on saying she because it's Gwen Wyckoff who wrote a lot of this book. And but in the book, she states that Charles Author is a trust. So that's what the name of the book, the author is Charles Author Enterprises. So anyway, I'm done. Thank you very much. Thank you very much.
Thank you very much for that tip there. If you guys heard that, The Art of the Book, The Art of or Passing the Buck, volumes 1 and 2. Let's all check that out. We all need to know.
Thank you.
In addition to the Wise Concise Handbook book, let's get a copy of it and check it out.
I actually made a copy. Went to the store and actually had it binded yesterday. Thank you very much.
All right.
Hey, Avery, I got 2 good questions.
Please do. Go ahead.
Mike Butterfield asked, he said, I was adopted by my stepfather at 13 years old and have authenticated my birth certificate in my adoptive name. I still have my certificate of live birth in my birth name, which includes my sole prints and mother's signature. Would it be beneficial to authenticate that as well?
It doesn't hurt. It does not hurt at all. But your name didn't change at all. That's on birth. On both birth certificates, your name is the same, I'm assuming. On both birth certificates, your name is the same, I am assuming. So if that is the case, then you don't need to do both of them, but it doesn't hurt to do that and list it inside of your okay, so you have different names on each. So on one, which is the first one, it is your birth name, and then you're adopted at 13, which you took on a different name for those parents. You always want to go off of what is current. All right. So when you're adopted, that is usually the document that is going to stand as true going forward with your social security card. So whichever name is on your social security card and your driver's license, that is the birth certificate that you want to focus on. Hope that answers that question for you, Mike. All right.
All right, I got one from Dwayne. He asked, does listing your property in the trust document trigger the clause in the promissory note for mortgage to have the bank demand the remainder of the mortgage immediately?
Good question. I'm going to go and share my screen and put that to rest. And I'm sure Brad can answer this question as well for you guys dealing with real estate. You're going to search the Garn and St. Germain Act, Depository Institutions Act 1982. And let's go ahead and check it out on Wikipedia. You can look at all the sources down below, but let's read right here. Zoom in. It says, an important consumer change was to allow anyone to place real estate consisting of 1 to 4 dwelling units into their own trust. Need I say more? Without triggering the due on sale clause. The due on sale clause allows lenders to foreclose on a current loan upon transfer to another. This greatly facilitates the use of trust to pass property to heirs and minors. It may also protect the property of wealthy or risky owners against the possibility of future lawsuits or creditors, because the trust owns the property, not the individuals at risk. So this is why I told you guys with that South Dakota law, Title 53, if your property is recorded in trust for at least 2 years, and you entered into, let's say, some type of foreclosure or bankruptcy, insolvency estate, the creditor cannot come to you and make you sell the property because you have that trust has owned that property for at least 2 years. So it doesn't look like the trust is trying to defraud the bank. Donald Trump uses this. Mitt Romney uses this method. This is what it's all about. So no, if you put it into your trust, you are not going to cause the loan to be due on sale clause. That will not trigger that. So, and if anybody at the whoever your third party loan servicer is, if they tell you that, you simply tell them Public Law 97-320, House Resolution 6267 says no under this act. Okay. Next question.
All right, Frenchie asked, do you suggest doing an auto bond to replace auto insurance?
No. It's been done. It's been done before, but that is a heavy question. I can't answer that
That's
right
jamming
now.
right there. Yeah.
Yeah. Why doesn't everyone use South Dakota as their state of trust? Well, I recommend it. I recommend everybody records their trust in every state, but get it in where you can get it in the easiest. And right now, that's states like Florida, Texas, Virginia. No, not Virginia. I'm sorry. Arizona and Ohio. But yes, South Dakota is one of those that you definitely want to get your trust in there. And when I show you guys the bond, it's not going to be a problem for any of you to do it in South Dakota. But I will say this, we've got about 60 people that have come into this class today. We're down at 49 because time is going long. And we're going to cut it at this point. But if all of you who are in here, 60 people, and you get it recorded in South Dakota, you're going to be using your own format. You're not going to be using any templates that I give you to do it. We're going to show you how to do it, but you're going to type it up. And you are going to choose your own county, right? So we don't want all of you going into the very same county because that's not going to be productive for everybody here. All right. So I'm going to take one last question, and that'll be it for today. Going to Miss Oldafin, you are unmuted. Just unmute your mic.
Good day, Avery and everyone. Thank you for taking me. My question is about if my birth certificate name is different than the Social Security name. Do I need to do a name change, or can I just establish myself now with my birth certificate now that it's authenticated and all?
Good question. I've actually never ever seen someone have that, but doesn't mean we don't know what to do with it. You have to use the name that's on your Social Security card. That'll be the information you give the IRS to get your estate number, because that's the only way that they can find you. You're going to authenticate your birth certificate, which you've already done. Now, when you list that inside of your trustee minutes and your non-UCC, those two names will need DBAs with the trust. And I'll show you how to do that with an affidavit. So you have two names to be listed inside of your trust, where the trust is doing business as the birth certificate name and the trust is doing business as the Social Security card name. When you do your name change, that's going to be whatever title nobility name that you selected. Your trust will do a DBA for that as well. Once you get that court order, you're going to use that court order to apply for your passport, and it will allow you to get your passport without giving any Social Security number. And that is what you want, ultimately. From there, that will allow you to update your driver's license information as well. Most people would say having a driver's license is being under their authority. I would say it depends on the information that you've given the DMV to be under their authority, which is that you're a US citizen and that you've given a Social Security number. So when you have the proof from the Department of State with your name change that you didn't have to provide a Social Security number, you're going to do the very same thing down at the DMV. And there you will have two different records that is private. It looks like everybody else. That is exactly what they want. They don't want you to have something completely different than the world, but you know who you are. And that decree is all that matters, because on that decree, it's going to show your old name, your new name, and your title of nobility with your nationality. If you watch version 2 in the freshman course, you'll see what I'm talking about when it comes to the name. All right. How do I pronounce your first name? I'm sorry. If you're still there, Miss Odolphin, how do I pronounce your first name? Is it Omalara? Omalara? Never heard of that name. All right, so I think we got everything, Isaiah, for now. We've got, I think this is the longest class that we've done on a Saturday. So next time we meet up is going to be, let's see, it's the first Saturday of each month now going forward. So that would be March 4th. March 4th, we'll come back. We'll have another 2 to 3 hour Q&A. And the 15th of this month, private clients will have an opportunity to come and talk as well. All right. So with that being said, I appreciate all the questions today. Very, very helpful for all of you guys. Please stay the course, and let's accumulate the wealth and asset protection that we all deserve. Thank you, Isaiah, for hanging in with me today.
Peace.
Peace, you guys.